Hello, I'm Jackie Marchington from Cordex, where I'm Director of Global Operations, and I'm going to talk to you today about being a corporate author. Just some disclosures. Views and opinions expressed today are mine. They're based on personal experience, and please don't take them as legal advice. Copyright and publications. We're talking about pharmaceutical industry-sponsored publications, and most pharmaceutical companies are quite well set in terms of policies regarding the publication ethics and data disclosure and transparency, having policies that are built around principles of good publication practice. Copyright doesn't really fall into either publication ethics as such or data disclosure, so quite often there are gaps in policies regarding copyright compliance. And also most people in the pharma industry tend to think of copyright in terms of permissions, so needing permission to use material, needing permissions for promotional materials, what have you, rather than in terms of possession or something that is owned by a content generator. So just to run through sort of the major copyright stakeholders in pharmaceutical sponsored publications, there's the publisher, whose copyright stake is granted by good old-fashioned copyright transfer or publishing licenses, depending on whether they're traditional publishers or open access publishers. And traditionally, copyright transfer has been the price that authors pay to have their work published and disseminated. So they basically hand over their work, and there's little or no cost to the author, but the publisher requires the commercial exploitation rights to recoup the cost of publication. That's kind of the original basis of the publication transfer in academic publications. So the publisher gets given the copyright when the author is ready to publish. The sponsor, the pharmaceutical industry in this case, has no real copyright stake in a publication which has been written by external authors. So there's no copyright piece for the pharmaceutical company to be worried about generally at this stage. Then the author and creator are the people actually understand about having copyright. These are the people who own the copyright because they generated the content. So this tends to be the authors. It could be external academic authors. It could be company authors or vendor authors who are working for the pharmaceutical company, in which case the sponsor comes in with the copyright stake, because the work was created as part of your employment or part of your contractual obligations to a third party, then it's most likely becomes a work made for hire. So on a clinical paper, co-author mix might typically be a few investigators. You might have pharmaceutical company employees such as the clinical trial lead, statistician, and the medical director. So you'll have a mix of external academic authors and internal corporate authors. And for something that is mainly a sort of health economics, outcomes research or real world evidence paper, you may have an external clinical advisor who would be an academic. You may have, again, pharmaceutical company employees, such as the person who commissioned the HOR study, medical director, a statistician again. And you'll have another group of authors who are potentially the third-party vendors, so the analysts who conduct research and do the analysis on the third-party database or whatever. So you've got a different mix of authors, but again, you've got a mix of academic authors, corporate authors, and then vendor authors. So what is work made for hire? It's actually a US legal term. It's in the 1975 US Copyright Act. And it's described a work subject to copyright that is created by an employee as part of his or her job. And there's some limited extensions to that as well. So that's the definition of work made for hire. In the UK copyright law, it's not phrased work made for hire, but the implication is the same. So work's created for an employer. So where a literary work is made by an employee during the course of their employment, his employer is the first copyright holder. You have to be a little bit careful. There's no definition of what employee is in the Copyright Designs and Patents Act of 1988. So you need to be aware of whether you're an employee working with a contract of service, in which case you're an employee and the copyright goes to your employer, or you're a freelancer or independent contractor where you're working under a contract for services. So the copyright status of your work will depend on your agreement with that third party. So, a little bit of pop quiz. Some scenarios just to help you understand a little bit better how it works. So imagine you're an academic, you've been invited by a journal editor to write a review for his or her journal. Is that work made for hire? No, it's not work made for hire in terms of the journal. It's a solicited review and they're not paying you. So the journal has no work made for hire stake. If you write it as part of your duties as an employee, then your employer may own your work. But if you're writing it in your spare time or independently of your employment, then it's definitely not a work made for hire. So that's a no. Next scenario, you're an investigator in a clinical trial for which your department received grant funding, and you're participating in the writing of the paper. So would that be work made for hire? Again, no. Your department receives funding for the trial, not for the writing up of the trial, and you're not being paid to participate in the writing. It's not part of your duty as an employee because the research was carried out under grant funding, not employment funding. So it's not work made for hire. If, however, you're doing this in work time, and it can be considered part of your duties as an employee, then it would be work made for hire. But generally, clinical investigators working on pharma-sponsored publications are not doing it as part of their employment, so it's not work made for hire. This one's the easy one. You're an agency medical writer who qualifies for authorship on a review paper. Nice and straightforward. Yes, it's definitely work made for hire. You're employed as a writer, you're being paid to be a writer. Your contribution belongs to your agency, and most likely through your client, your master service agreement with your client, it will be transferred to the pharmaceutical sponsor. So that is most definitely work made for hire. Slightly further apart, you're a research analyst working for an HEOR agency and writing up the analysis you performed with your client for publication. So is that work made for hire? Yes. Again, you are paid to do the analysis and to participate in the writing. Your contribution belongs to your agency, and again, depending on the contract between the agency and the pharmaceutical sponsor, indirectly to the sponsor. So definitely work made for hire there. Now the last one I just want to go through is a slightly more complicated one, and it's one we have come across before. So you were an investigator in a clinical trial, which your department received funding from the sponsor. You're now between jobs. But the trial sponsor's taken pity on you and is deciding to pay you to help write up the paper. So is that work made for hire? And with all good copyright questions, it depends, has to come in somewhere. You're not employed, so there's no consideration for work made for hire due to employment. But you are being paid by the sponsor, so it kind of depends on what your agreement with the sponsor says. So if you remember a couple of slides back, I was talking about contract of service and contract for service. So you need to make sure in your agreement with the trial sponsor what your copyright status, what the ownership status of your copyright in that work is. So if your contract says, and we own the copyright, then the sponsor does. If they didn't think to protect themselves, then you do. So that's a good old it depends answer. So work made for hire is technically straightforward, but actually could be quite complicated. Why does it matter? After acceptance of a manuscript for publication, the authors enter into a contract with a publisher to have the work published. As I mentioned earlier, the academic coin of handing over your copyrights in exchange for having your work published and circulated to the subscription base. So these agreements may entail something as straightforward as assertion that the research is original, not been submitted for publication elsewhere, that the work is accurate, and there'll be all sorts of indemnification clauses against any breach of the publishing conditions. No one ever reads these, by the way. Transfer of copyright might be in there, and if there's not transfer of copyright, there still may well be an execution of a publishing agreement. And you need to have the legal authority to enter into these agreements. This is a not atypical copyright transfer form. I haven't asked for permission to use it. I'm going off for fair criticism and review. And quite often, these are kind of designed with the academic research community in mind. So it says, no, the corresponding author is authorised to communicate with the editor of the journal on behalf of all the authors. I've never seen anyone sign anything to that effect at any point in the publication process, very rarely. The assumption is that amongst the academic chums publishing together that they're quite happy for the corresponding author to do that. That can't be the case if some of your authors are corporate authors, because they're not legally authorised to enter into any kind of agreement like that. And you get check one. You can either have author-owned work, or you can have work made for hire. And of course, if you've got a mix of authors, as demonstrated earlier, there's not one group that these people fall into. So these standard forms are a bit problematic for the pharmaceutical-sponsored publications. There are different types of forms. There are joint and individual forms. The joint ones are more problematic. These, just the one I just showed you, corresponding author signing on behalf of all co-authors. So they're problematic if co-authors are company employees or vendors, or even if the corresponding author is a vendor, which is not uncommon for HEOR kind of publications. And And then the individual forms are actually easier to deal with because each author signs their own, so they can either pick it's mine or it's work made for hire, and that's actually much more straightforward. The only thing you need to remember is the vendor authors often need an authorised signature on their form, not just them signing it themselves as well. Practically, why does this matter? Again, there's a huge ignorance of work made for hire requirements amongst staff and amongst vendors. Even if there's an authorised signatory process in place, publication leads often don't know about it or they haven't come across it. Everyone hates copyright. No one wants to find out about it anyway. It's easier not to ask the question sometimes and makes life easier for ourselves. But if you read the small print in master services agreements between agencies and clients, which I spent a lot of time doing, there's usually some kind of wording in there about maintaining copyright compliance and assisting your company contacts to remain compliant. So it's you're kind of honour bound to point out these things to people, or contractually bound actually. Things you need to think about when you're working through these publication processes is who is an authorised signatory. It can be basically anyone legal says. We've worked with global publications leads as authorised signatories. An IP lead in legal might be an authorised signatory. One company we work with decided they're going to waive the authorised signatory rights and allow employees to just sign them anyway. I think that's more out of simplicity than anything else. Another client that we work with, everything goes to IP regardless of who the authors are. So all the forms are signed off by the IP department. So it varies between companies. GPP clarifies that authors can be paid for working on publications, but as I mentioned earlier, it's only ever work made for hire if it's specified in the author agreements, and I've never seen anything regarding copyright in any author agreement I've ever seen. And then you need to think about vendor agency staff, whether they're aware of the authorised signatory process, whether their company is aware of the authorised signatory process and how they fit into it as well. So there are quite a few things to think about around work made for hire. So from a workflow process, this is why kind of thinking it through from the start. If you're working with a client, an agency working with a pharmaceutical client, find out whether there's a authorised signatory process in place. If there isn't, you might need to go back and ask those hard questions and establish what their requirements are. If there is, great. You can then move on to looking at the submission in hand and seeing whether the copyright transfer forms and publishing agreements are available pre-submission. Quite often you don't get access, particularly on the electronic submission systems, you don't get access to these forms until after the manuscript's been accepted, so you can't always see them and plan ahead. But if you can get a chance to look at them in advance, check for whether they're paper or online, because paper forms are a lot easier to amend than online forms. They're joint versus individual. As I mentioned earlier, individual assignments are much easier to cope with than joint ones, and whether they include any provision for work made for hire in the process. And be prepared to contact the editorial office if the forms aren't going to meet the requirements of your authors. Again, you're not likely to be doing this before you submit, but if you know that you're going to have to get the forms amended, you can at least try and make contact and find the right person who understands the question at the publishing company. If the forms aren't available ahead of submission, be prepared for delays once you find out what they are. And then when you get to submit, you can start the dialogue with the publishing company, the publishing editor. Aha, I hear you say, let's avoid copyright transfer completely and go the open access route. Then we don't have to worry about copyright transfer. Sadly, as is often the case with open access, it doesn't really make things easier. There's massive variation on how open access is and how the term open access is interpreted or described by various publishers. Many open access publishers, or they describe themselves as open access publishers, are more public access, so you still do the full copyright transfer, but the article is free to read. Even if you're going Gold OA, where you're working under Creative Commons license, you may find that there's still a publishing agreement to be executed. And again, although not a copyright transfer, it still needs to have somebody with legal authority to execute that transfer agreement. And under the CC BY licenses, which have a non-commercial clause, there's almost always a transfer of commercial rights to the publisher, and that needs to be executed by a legal signatory. So these strictly aren't copyright transfers, but there's still things to think about in terms of having a legally executed agreement. So lovely though open access is, it doesn't solve any of these problems. So, in summary, think about building copyright compliance into your publication SOPs if it's not already there. Find out who your designated authorised signatories are, and please make sure they understand publications, because if you're working with a lawyer who doesn't want to sign off IP because she's just thinking IP rather than the learned journal academic publishing process, you have a mountain to climb to explain what's going on. Review the vendor author practices and ensure the appropriate signature processes in place for those, and read the small print, because agencies spend more time reading small print than the rest of the stakeholders put together, so know what you're up against. So life as a corporate author can be tricky, but if you plan ahead and think about it, it's relatively manageable. So thank you very much.